Welcome to You and the Law, a Chicago Bar Association production that provides information on a variety of legal and policy matters of public interest. I'm Mike Al-Karaki, a partner at the plaintiff's personal injury firm, Leahy Hosty Al-Karaki. I'm an adjunct professor at Loyola Law and a member of the Chicago Bar Association, where I serve on the Judicial Evaluation Committee, Trial Practice Committee. I'm the chair of the committee that puts on this show. I'm also a mediator in the program that we're going to be discussing today. And today's program is another in a special series that focuses on the CBA as a public resource for services, community engagement, education, and advocacy. And in particular, on today's program, we will be discussing the recent formation of the CBA's mediation service. And we are lucky to have with us two very special guests. Mariam Ahmad is, among other things, the president of the Chicago Bar Association, the chief of the Juvenile Justice Bureau of the Cook County State's Attorney's Office, and a former judge and former public defender. Judge Thomas Mulroy is a former and recent Chicago Bar Association president, a sitting judge in the Circuit Court of Cook County Law Division, and the chairperson of the Chicago Bar Mediation Service. President Ahmad, Judge Mulroy, welcome to the show, and please tell us a little bit more about yourself. President Ahmad, why don't you start us off?
Sure. Thank you, Michael. Hello, everybody. As Chief of the Juvenile Justice Bureau for the Cook County State's Attorney's Office, I oversee all of the Child Protection Division prosecutions, which involve the prosecution of abuse, neglect, and dependency cases. I also oversee all of the Juvenile Justice Division prosecutions, which are the criminal juvenile prosecutions. As Michael mentioned, I'm a former circuit court judge, and before I worked as a criminal attorney, I was a corporate and civil litigator. So I am experienced in the court system and understand, particularly now during the pandemic, that the significant number of cases that have backed up in our court system are a concern for the administration of justice. So I'm happy to talk about the Chicago Bar Association mediation program today.
Thanks,
Thank
Michael.
you very much, Judge.
It's great to be here, and especially great to be here with Mariam, who is a very experienced lawyer and a very experienced mediator. She does, and negotiator, I should say. She does all kinds of negotiations 24/7 in her job. So I have been a judge for 15 years, I think, and I sit in the commercial calendar section of the Law Division, which handles business cases. And 5 years ago, I was asked to develop a program for mandatory arbitration for smaller cases under $75,000 in the commercial section. And I put together a program and wrote rules that applied to it. With the input of about 30 lawyers who practice in the commercial section. And the program, the mandatory arbitration program, has now become the most successful court-ordered arbitration program in the state by any measure. One of the measurements that we use is the amount of rejections that we receive, and we have a very small percentage of arbitrators' awards are rejected by the parties, which is wonderful, and how it influences settlement. 55% of the cases that are referred to this mandatory arbitration program settle before the hearing is even held, and 97% of the cases settle short of trial. It's a great program because it speeds up settlement. Look, nobody can afford lawyers to fight for them for 2.5 years in court. Big companies complain about it as much as small companies do. This mandatory arbitration program that we developed in the commercial section brings parties together faster and makes them settle faster. And, you know, that's great. It's great for the clients, and it's really great for the lawyers. We're talking about smaller cases, and a lot of times lawyers have difficulty navigating payment issues in smaller cases. And of course, clients get tired of us and angry with us. Litigation process is very tedious, as Dickens wrote in the 19th century. So that, and I'm getting ahead of myself, Michael, but that experience led me to suggest to Mariam and others at the Bar Association that they consider the Chicago Bar Association taking on a mediation program, and that's the subject for today.
Great, thank you for that introduction to yourselves, your background, and also the program. And why don't we start with, this is a public-facing, kind of consumer-facing type program, so not everyone who will be watching this will be lawyers. Certainly, we hope there will be some lawyers. I think there will be. And I understand that as part of this program, there has to be, in order to be eligible for a case to be reviewed or involved in this program, there's got to be parties have to be represented by counsel as opposed to pro se. So if you don't mind, if either one of you can tell us a little bit about that, but maybe first even start, because we've got some non-attorney viewers, with what mediation is, as opposed to, or peripheral to, or in the context even of litigation.
Judge Mulroy, why don't you talk about how mediation is used in the First Municipal Division and throughout the Circuit Court?
We have a mandatory mediation program in the Circuit Court of Cook County, but it's not widely used. So there's two kinds of alternative justice systems here. One is where the parties agree to mediate or arbitrate their case. And the other is where the courts can require you to go and mediate or arbitrate. So if it's court ordered, we call it mandatory mediation. And the mandatory mediation program in the municipal section and in the law division exists. It's not as successful as we would like, because it's hard to order parties to mediate, as opposed to ordering parties to go to an arbitration. See, an arbitration is where an arbitrator, a neutral, actually makes a decision in your case. A mediation is where two people get together and they, try to resolve the case. And sometimes, especially early in a case, as Mariam will tell you, the earlier in the case, the more difficult it is for parties to put their emotions behind them and to kind of sit down at a table and mediate.
So, Michael, most of the folks who might be watching might be familiar with mediation, for example, in family matters. In marital dissolution cases, divorce cases, often the parties are required to mediate at some point. And as Judge Mulroy indicated, to sit down and talk with one another to attempt to reach a resolution on a case and on a particular issue surrounding a case. And the reason why mediation is more significant now in this particular period of time is because of the global COVID-19 pandemic. Our court operations ground to a halt in many respects. And now the court system is facing a tremendous backlog of cases. So one of the reasons why the Chicago Bar Association is involved in mediation is because one of our core principles is that of the administration of justice. So, but what better way to take advantage of the skills and abilities of our attorneys and assist the court system, but through this type of program?
And that's a great point. And in addition, or in your point, is that it helps the litigants and it helps the lawyers. The lawyers, of course, are members of the Chicago Bar Association, but it also helps the litigants come together and try to resolve their differences through voluntary mediation. So this would not be court ordered. It's offered by the Chicago Bar Association. It's voluntary. And you can become a mediator in the Chicago Bar Association program if you've been out of law school for 10 years. And if you apply and you have had taken some specialized training, which we also offer, but Harvard and UCLA and other places offer this specialized training. But mediation, to be a mediator, is a real skill. And so we have 30 lawyers. You have to be a lawyer to be a mediator in this program. But of course, we are explaining this program to clients because clients can also go to their lawyers and say, hey, why don't we go look at the Chicago Bar Association mediation program? It's less expensive than it is than other private mediation services cost. We charge $400 an hour. So that's split between the two sides, $200 each. There's a minimum of 4 hours that you have to pay for. And the mediator, him or herself, gets $350 an hour. And the Chicago Bar Association keeps $50 an hour to kind of administer the program. It's a great alternative, and it's an unusual thing for a bar association to offer. Most bar associations don't have a mediation program where their lawyers can offer them their services to clients to help resolve their issues. And it's great for civilians, for non-lawyers to know about this. And one of the reasons we were so delighted that Michael invited us today was to get the word out to folks who are engaged in a dispute. I mean, a lot of people have disputes with their neighbors. A lot of people have to go through divorces, foreclosures, bill collection.
Eviction, consumer debt.
Right. We handle all of that, even zoning disputes. We have lawyers who specialize in those areas of the law who can help you mediate your dispute.
Sure.
There's something else. I'm sorry, Mike. I didn't mean to interrupt.
Go ahead.
There's something I wanted to add on in terms of what Judge Mulroy said. Mediation gives you a modicum of control regarding the outcome, because it's you and the other parties working together for a resolution versus handing the matter over to the court, which will then make a decision on behalf of all parties. And so that bit of control is one of the advantages of mediation versus pure litigation before the courts.
Great point. And you don't have to have been sued to use this program. If you are having a dispute, you can come here and we will assign you a mediator. You can select a mediator from our list, someone who's well-versed in the issues of your dispute, and you can mediate it. The only requirement that we have is that the clients, the principals involved in the dispute are represented by lawyers. But it doesn't matter whether it's a huge case or a small case. Chicago Bar Association mediation program is available.
Great. And there's a lot there to kind of unpack, and I want to pick a couple sort of foundational matters. One is you had both referenced sort of an acute need that this program serves as the courts are doing their best to move these cases along under difficult circumstances. And we all know, I mean, look, I do plaintiff's personal injury work, and we, in all types of cases, we need those trial dates for everybody's benefit, because that's oftentimes when the real settlement discussions happen, right? When the reality of trial brings people into that mindset. And without that, I don't think I'm going out on a limb to say that it's been a little bit more difficult for parties to resolve cases. And I presume that's the case across practice areas in litigation right now. So there's definitely that acute need. And I don't know if there's any insight that you might want to share in short. I'm sure it's a long story, but how things are looking in terms of resuming trials at some point. So that's sort of one aspect of it. The other is beyond just the pandemic and the short-term, pronounced need. What is there? Where is the sort of underlying and you mentioned it could be a cost issue because there are other services out there for people who are willing to spend sometimes quite a lot of money to get a third party or neutral involved. But if you can address a little bit, and I know that I packed a lot in there about the short-term need and also the sort of, long-term, role that you see this program having in our legal community.
Yeah, speaking of a lot to unpack,
Yeah, right.
there's a lot to unpack in what you just said. Let me say that we are surprisingly in the commercial section, which is 10 judges who handle non-personal injury cases, civil cases. We are starting to reduce our backlog now. And for the last 3 months, our cases have gone down, which means we've been able to dispose of a great many cases through Zoom. And of course, we do our bench trials on Zoom, which reminds me to say to you that we do mediations on Zoom as well. And I've done several mediations on Zoom with my own cases. And it works. It works, I'm happy to say. So even though this pandemic, we see the light at the end of the tunnel, I think we're still going to be virtual for a while. It was reported in the newspaper today that they have sent out, and Mariam can talk to this, the Chief Judge's Office has sent out jury notices to see if they can start bringing jurors in to try criminal cases. So I think the end is near. But there is a backlog. There's a backlog. Mediation is one way to resolve the backlog. 85 to 87 to 88% of all cases settle. I think it's higher in criminal cases. I think that's about what it is in personal injury cases. And that is what it is in civil cases, 87%. Look, it's better to settle early rather than later. You don't want to spend $10,000 in lawyer's fees and then settle. You want to settle before you spend the $10,000 in lawyer's fees. And if you can get the parties to a mediation program with trained mediators like Chicago Bar Association offers, I think it's a great way to reduce the backlog in court. It's a great way to give something of value to your client if you're a lawyer. And even though it's hard to explain to non-lawyers who are involved in a dispute, the litigation process and its due process takes a long time. There's a lot of reasons why it takes a long time, but it does. It takes a real long time now.
Mhm.
And we worry that justice delayed is justice denied. And we worry that this COVID pandemic is impacting our right to access justice. One of the things you can do if you're involved in a dispute is to mediate. Right,
Michael,
Mariam?
that's correct. Michael, I'd like to go back to a phrase you used, and you used it in the context of COVID. You said acute need. There's actually, COVID is just one form of an acute need in terms of impact on the court system, but an acute need can be caused by the expiration of a rental agreement or the expiration of a contract or some other external circumstance necessitating a resolution sooner rather than later. And that therein lies one of the major benefits of mediation. Those cases move more quickly.
And then in those needs that you had just mentioned, those are likely, to persist well after some degree of normalization, has returned in terms of the court system. So those are important points. And I'd like you to, if you're able to, Mariam, please tell us a little bit more about how you, and I think Judge Mulroy had mentioned this also, but if you could mention how this program, or elaborate on how this program kind of fits into the CVA's broader mission with respect to improving the efficiency and effectiveness of the administration of justice and also access to legal services.
Mm-hmm. And so let's using your phrase unpack what the administration of justice means. That means creating systems whereby cases can move through the court system efficiently. One of the factors that can affect the administration of justice is the length of time in which a case takes to work its way through the system. The CBA, Chicago Bar Association, membership is comprised of lawyers and judges, but primarily lawyers. And one of the things that we do, just by virtue of our own profession, is practice law, and do everything connected with law, from filing cases to litigating cases in the court. So one of the logical connections for the Chicago Bar Association to undertake this type of program is to ensure the continued smooth operation of the court system while benefiting from the talent, skills, and abilities of our attorneys. That not only affects in a positive way the court system, but individuals in our community, to allow them access to courts and allow them access in a way that they can afford.
Sure. I'd like to follow up on that if I could. I mean, I think one of the sort of maybe benefits that's wrapped into this is to the extent that you know, members of the community and the public they're able, in a mediation, like one of you or both of you mentioned control, right? So this is almost, it can be an education process also for the parties involved, so they can really see the way the machinery works in a way that they really understand and feel comfortable with. So hopefully that's something that I think is wrapped into the program itself and consistent with the CBA's broader mission, if that makes sense.
Yep.
There's Judge Mulroy alluded to something. He talked about the fact that mediations occur on Zoom. That reminds me of a quote from Chief Justice Ann Burke. Ann Burke talks about the fact that the administration of justice and justice itself is a service, not a place. One of the benefits of mediation is that it can occur outside the framework of an actual brick and mortar courthouse, which again increases the access to justice of the members of our community.
Yeah, that's a great point.
Sure. We have, in the course of the conversation we've had so far, gone over some of the procedures and kind of mechanics of starting a case in mediation, whether it's from a potential, whether it's from a party or an attorney. But if we could drill down just a little bit, and we do have a little bit more time, on how someone, whether it's an attorney or a party or a potential party who has access to counsel, can get involved with our program, and what's that going to look like? What's their first move?
So the program has its own website, and Michael, I'm hoping that you can publish that on here for the viewers. And you go on the website and you can scroll through the mediators who are qualified and who have signed up to work in the program, and you can pick a mediator and you send an email to our administrator, and that starts the process. Make sure the mediator has no conflict of interest. Make sure that he or she is truly a neutral. Make sure that he or she has the expertise that you're looking for. And as I said, we have lawyers from all areas of the law who are participating here. And after we put you together with the mediator then sets the time schedules and also requires certain information from the parties, a summary of the case and kind of a chronology of the case, what's happened in it so far, and the parties' names and that kind of thing. And then you have a mediation hearing, and most cases we found can be resolved in about 4 hours, maybe 5 hours, but most cases are resolved in that period of time. And the idea is, after you've selected your mediator, to start the hearing right away. We want this process to be effective and efficient, fair, of course. And I think that the structure is simplified so that, I don't want to say it's like buying a car where you scroll through Fords. and you pick the one you want. But that is how you select the mediator. You look at the person's qualifications, and then you see if that person's available. It's pretty straightforward and simple.
Sure.
But that's an important aspect, Judge Mulroy, because when you go to any courthouse in Cook County, you're not scrolling as a litigant. I promise you,
Right.
you're not scrolling through the roles of the judges and determining the judge that will hear your case. Your judge is assigned randomly. So that again is another element over which litigants have some control.
And, you know, not only are these lawyers who have been accepted as mediators in the Bar Association program experts in their field or well-trained in their field, they've also been trained as a mediator. I referenced that a minute ago. The Chicago Bar Association also put on, offers an intensive mediation workshop. It's 2.5 days. It's very intensive and it's very detailed oriented about how to negotiate, how to be successful in mediation. And we are going to offer in April a practice workshop where folks can sign up for this virtual training session and actually do a mediation. We have 3 problems that you'll be able to mediate while experienced mediators watch you and give you tips and then discuss not only the strategies that would work well, but also kind of give a good explanation of what they would have done. I think it'll be, it's going to be an offshoot of our intensive training workshop. But I mentioned that just to give the folks who are listening to this program confidence that the people who are mediators in the Bar Association mediation program are really are people that you would go to for help, you know, in any serious issue in your life.
Sure, and it looks like we're closing up on time, but I will tell you, I took that program. It was fantastic. The faculty there is wonderful, and maybe a quick note on what your hope is, maybe under a minute. Your hope for the future of this program. I mean, I know it's early, but what do you see that's happening with this idea?
Well, you know, I think my hope is that this is really, truly a great service being offered by an association dedicated to service. It's a great service being offered to our members and a great service being offered to the public, to the clients.
Sure. Sure. Well, go ahead.
I was just going to say, just real quickly, my hope is that for those who have cases pending in court, that you see this as an affordable option. Unlike some of the other services that are more expensive, this is one that is actually most economical for residents who come from all price points. Absolutely.
Well, President Ahmad, Judge Mulroy, thank you both for appearing today to share information about this exciting new service, and of course for your work on this and many other things you do. And finally, of course, we want to thank our viewers out there. Thanks for tuning into this installment of You and the Law. Be encouraged to visit www.chicagobarmediation.org to learn more about the CBA mediation service. Thanks for watching.
Thank you.